it's actually so odd, because most people think that people should actually look at secondary sources first before actually even bothering with the actual law, because the secondary source will actually explain to them what the law means and give them an idea as to whether or not this is even what they should be dealing with. Okay, so primary law versus secondary law, it's all through it's through all of the legal writings that you guys are gonna look at and examine. All right, so let me just see how I can share the screen now. Let's see, screen share. 1%. Okay, now here. Okay, here we go. Okay. Let me see. Stop video. Can you guys see the screen? That's I'll show you. Just tell me if it's coming up.
Yeah, I can see it.
You guys see it, right?
Yeah, I can see it.
Okay. So what this relates to, my computer is like a little slow for some reason. Okay, what this relates to is what I'm talking about is law review. Okay, law review is essentially, if you're going to go to law school, right? You want to get on law review if you get to go to law school, if you can. Okay, law school is reserved. Law review is reserved in law school for the best writers, the ones who can, do research well and who can also write well. It's got nothing to do with litigation. So those people who are good, in court in terms of litigation, cross-examination and direct examination and things like that, it has nothing to do with that, okay? Law review are essentially scholarly articles that are written by law students for the purposes of ending up in a book. And they get published most of the time on a yearly basis. Some law schools produce two. All right. So as it says here, and I think I sent this to you, but if not, I will. Most articles are edited. Law review articles are edited by the law professors at the university. They will look over them. The students will choose a topic like what's going on right now. Might be medical privacy. That might be a topic, and they would if you had like 10 people on law review, maybe 4 of them, or maybe 5 of them would be assigned to two different topics, and the 5 would take one portion of this topic and do a lot of research on it. They would come together, it's almost like doing a thesis in graduate school, and they would essentially write on it, and that writing would be reviewed by law professors. Okay. These law review articles are published ultimately by the law schools, all right? And if you went over to St. Johns right now, if you went to the library, you could actually pull out several of their law review articles going back. Oh wait, manage participants. I'm trying to see if I know that anyone joined. 1 second here. Cursor. There's 11. Right? Oh, admit. 1 second. Let me just admit someone else. Okay. It seems that my cursor disappears when I'm doing this. Oh, another person to admit. Hold on a second. Let me just stop the share a minute. Oh, there it goes. Okay, admit. Okay, we got some new people who just joined us. Tina, right?
Yeah.
Okay, good. And Audrey. Right. Okay. Hey, Andrea, how you doing? How are you?
Hey, I'm pretty good, Professor. Thanks for asking.
Good, sir. All right. So let me just move this.
Just restart.
Yeah. if I can minimize this a little bit. Okay. I'll kill it. Okay, I minimize it. Okay. All right, you know what I'm gonna do? I'm gonna actually keep this screen like this because I can actually see the cursor, and it just doesn't disappear. All right, so for those of you who just came on, we're just going over law review articles, and that was just a part of what I was talking about. I will be sending this screen to you. So again, most importantly, if you went over to St. John's University right now, you can see, and you can just pick up their books of law review articles going back years and years and years and years. They've been printing them for decades, and every law school prints these things. And the important thing about these articles is that when you're doing research, and you should understand that a law review article is not a primary source of law. Okay, obviously, it is a secondary source of law. It is something that you would go to if you are trying to do some research, on a major topic, on a topic that is actually popular or going on right now. And the thing about it is that a lot of lawyers who actually do use these for informational purposes, they may argue and they may actually refer in an argument in court to certain law review articles, that might be written by, Harvard, Yale, St. John's. They may refer to those. The thing is that these things are persuasive. They're persuasive arguments that can be made by the by the attorneys. They have no precedential value. They're not law school. They're not legal texts by judges. They have no precedential value. But a lot of times they give a very good look into the way the law is moving. Which direction is the law moving as you go forward? So they have a lot of influence in terms of how they are viewed. So that's very important to look at. So I'm going to give you some information. Let's see. It was the first law review article came out in 1852. It was published at the University of Penn, the law review, and they have continued to publish it, over and over again. That is the oldest serving law review article in the country. And again, as it says here, primary function of a law review article: number one, to provide a vehicle for academic publishing in the field of law. All right. Number two, to express the ideas of legal experts with regard to the direction the law should take. That's what I'm talking about. It's influential. And also to provide the necessary background research for legal practitioners. It's actually the first place that you can go and grab a book and do some work if you want to actually do some research and get you started. Okay. All right. So some of you just joined. Just briefly, I know things are a little odd right now, and I expect that as the year is over, as we're starting to get towards the year, you guys have to make that option, consider that option regarding pass fail. And I did suggest to the other folks that while that's always obviously your decision to make, I believe here we're going to have at least another quiz and a final, and I don't believe that these things are going to be something that's going to just bog you down in terms of your understanding or your ability to do well in them, and that the opportunity to get a decent grade in this class is still highly possible, even given this scenario. So I just suggested that you give that pass fail option a little bit of thought before you just jump on it. Okay, fine. Now I want to talk about wills, because this is a topic that is going on. Unfortunately, it's hitting the the airways now in terms of a lot of wills are being either asked to be written or being written, because a lot of people just seem to be catching this thing and just going. So never before has this class actually culminated with what's going on socially at the same time as what we're doing right now. So a will is a testament, a will or a testament. So that means a will or a testament. And I told you the words are important. Or, means that a will or a testament, those are essentially they're the same thing, all right? they're just interchangeable. Sometimes a lot of times, if you look, so a pre-printed will at a either online or at some of these actually some of these stores that sell them, it would say last will and testament. That's the traditional terms that has always been for a will. So a will or a testament, okay, is a legal declaration by which a person, all right, the testator, okay, so that's a person. That means a person who's, who is making the will, the person who expects at some point when he passes or she passes, that this is the will that they're talking about. So a will or testament is a legal declaration. It's a statement, a written statement by which a person names one or more people to manage his or her estate. Okay, that's one, and it provides for the transfer of property upon their death. Okay, so this is not a living will. This is completely different from a living will. A living will is completely different than a standard will. Okay, the living will talks about how an individual who is facing a medical condition that is life-threatening, that it's likely they will not come back from. The living will explains to them how they want the medical community to deal with them. In other words, don't bring me back to life. Don't resuscitate me. If I become terminally ill. So a lot of times families argue about those things back and forth. If you have a living will, it sort of explains from the person of the patient actually what the hospital should do for them, and that carries a lot of weight. This is completely different. This does not kick into place until you what?
Until you die.
Right, until you die. Exactly. Exactly. Manage participants again. Is there anyone else here? I'm just looking. Okay, no. Good. All right. So, and the other thing it does, it provides for the transfer of that person's property upon their death. Okay, very, very important. The other thing is that inheritance, which occurs at the same time as an individual, as the same time as a will, is being executed, is the passing on, okay, of all of these things. It's the passing on of property, titles, debts, rights, and obligations upon the death of an individual. So how can inheritance, how can someone get property passed to them? What are they talking about? Can anyone tell me?
Would it have to be like written in the will?
Right, it would have to be written down. And what kind of go ahead, someone said, Oscar.
Wait, how would it get past them?
Correct, right?
Like in terms of like either through the will or through statute, through the, I think, EPTL something, like there's a process by, there's like a priority and all that, and who gets who.
Oh, so you're talking about probating the will. You're talking about probating the will, and you're talking about situations in which, like intestacy, where there may not be a will, and these certain statutes actually say when someone doesn't make a will, exactly how property, if it exists, should be distributed. But
normally it's through like a will.
Exactly.
And like a person, like I guess the person writing the will designates a person that they trust, like administrators that actually goes out and gets the deed and the whole 9 yards, and then goes to the person like, here, it's yours, something
Correct.
of that nature.
Correct. So what we're talking about is about property. Is property could be in all forms. Okay, property does not have to be like a house. Okay, property is the cell phone is property. Okay, money is property. Right, land is property. A home is property, a car is property, anything that's tangible, okay, is property. And someone might want to leave like all of their shoes, their red bottom shoes to somebody or whatever. That's property. So the inheritance deals with the passing on of that property upon someone's death. Titles. What kind of titles? How can someone pass on a title? What are they talking about? Anyone know?
Like
Yeah.
car title, maybe?
All right. Car title. Oscar, what are you gonna say?
Yeah, like car titles, and sometimes titles is used in tandem with like a deed. Titles and deed, interchangeable. So
Exactly. A title is
or stock
evidence.
certificate, for like a co-op.
Correct. A title is evidence of ownership. Okay. If someone says that car belongs to me, and another person is actually holding the title to the car that has their name on it, well, it doesn't matter, how much that person says that car is theirs. If they don't own the title for it, it doesn't belong to them. Okay. So a title is evidence of ownership. And again, a will, in a will, you can pass on the title to certain property, and that gives you the first level, and the only level of ownership with respect to that. Debts. Well, how can someone pass on a debt? And it's unfortunate, but how could it happen? Oscar.
Um, I believe like in terms of like if that person dies, like it might go to like the spouse if there's a living spouse.
Well, suppose that person died and they owned a car and they left you the car. Okay. Now until a car is paid for, okay, you buy a car from a dealership, right? When you buy the car from the dealership, you don't own the car. I mean, on the title to the car would have your name on it, and the deal and the bank's name on it, your name and Citibank's name on it, and only when you pay off the car, all right, do you get new title. You get new title. You go back and they'll issue a new title, and this only has your name on it, right? So that's one thing. Now here's the problem: is that if someone left you a car that was leased, all right? What time we removed 40 minutes? Okay, good. Oh, Zoom said they've removed the 40-minute time thing. Okay, that's good. So if someone left you a car that they had purchased, all right, but money is still owed on it, all right. They buy a car for like $15,000. They put down $7,000. They die. They still owe they still owe like $8,000 on it. You got a car, but you also got a what? You got a debt. You understand? So they passed on that debt debt to you. Maybe they didn't intend to. So how can you fix that? What could you do? What's an option? Anyone know? What could you do with the car?
Wait, what could you do with a car?
Yeah.
Could you sell it?
Like sell it?
You can sell it. Right. Exactly. Yeah, I mean, you can sell it. You don't have to just sit on, Now, on the other hand, you can, if the car was nice enough and you liked it enough, and you got a good enough deal on it, you can simply just keep paying for it, because now what Oscar was talking about is probate. In other words, when someone dies and they left a will, everything that is left to people just doesn't go to them, just automatically, because someone has to change the title. Someone has to change the deeds. So how does that happen? What happens is that executor, the person who's named as executor in the will, okay, has to initiate a court process, usually with the lawyer. You don't have to, but most of the time with the lawyer, and that will is probated, meaning that it goes to court. And in court, a judge is going to find out, is going to look at the will, and he's going to also want to know how much debt does this person owe, how much property does this person have, and how much, he might, when you die, you could die owning a student loan. Okay, federal government's still going to stand in line. They're like, I want my money. Right. So if you died and you just happen to have $300,000 on you, when you died in your bank account, and you still owed $50,000, and you were trying to give away $300,000 to your mother or your spouse, whatever, the federal government's going to stand ahead of them and take their $50,000. So there's an order of priority in terms of your creditors. So Macy's, they're not going to get anything. They're going to be kind of low, but there's certain people, certain institutions that will always get their money. But the will has to be probated. When a will is probated, it means that car that your uncle or whatever left you, that title in it can legally, because of the court, be put in your name. Okay, so that's how you can ultimately get a title that actually shows that it belongs to you. It gets put in your name. So debts simply mean that just because someone is leaving you something, they may be leaving you something that is encumbered, by fiscally encumbered, that people still owe money on it. And since it's left to you, you have the choice to either keep it, sell it, or do whatever you want with it, and that's it. What about rights? Rights. How could you inherit a right? What's an example of a right you can inherit?
I know that in terms of like probate, I don't know probate, but like even in wills, like you can maybe like own something in a company, like they may give you like a share or something of a company, maybe that's a right.
Okay,
or
right.
like, or,
Well,
or if your father was like an inventor of this, he'll be like, okay, here, this is like the rights of the product.
right. That's more or less what I'm talking about. In other words, you may have entertainers. This happens with entertainers a lot. People who are who write songs. When you have people who are entertainers, there's a difference between people get paid to obviously to do music, but the people who write the music actually get paid a lot more, especially if it's a good song. They get paid a lot more than the people who sing the music, just generally over time. Okay, sometimes people who just perform it, they get performance money. Maybe they do a couple concerts, whatever. But if the song is good enough and keeps getting played over and over and over again, those people are entitled to royalties. Okay, that means that every time that song is played on the radio, that station has to pay 5 cents up to 2 to 5 cents every to ASCAP, these music places that collect the money, every time this song is played. And that's done all around the country, and that's how people the writers actually make a lot of money. If you wrote a great song, for example, when you die, okay, and this is a song that gets played every year. Look at Mariah Carey's; her stuff gets played every year. Every Christmas it gets played. Okay, she can actually leave to her children the right to claim all the royalties from whatever Christmas song she is played every Christmas. That might make someone a millionaire. So you can leave someone the right to that money. If your uncle
Like
or
up to like 90 years after death.
it just go forever, right? Yeah. It's not something it's not like a patent. It doesn't fall into the public domain, right?
Oh.
Right. So that is something. You may have a relative that owns an apartment building. You might leave them the right, okay, the right to collect all the rent, in that apartment building. So suppose it was paid off, So there's a lot of times that you can, leave all these things: properties, titles, debts, and rights. You can also inherit an obligation, okay? An obligation is probably in the form of an accounts receivable. In other words, you might owe money. You might have to do certain things. A lot of these things you would hope that your relative takes care of before they die, and they don't encumber you with things like this, or maybe they would have spoken to you about it. But these are the things that happen. No, okay, let me just check the screen again to see if anyone else is here. Manage participants, admit Jugs. Someone else just came in there. Hi, Jugs. Hello. All right. Someone else just joined. Okay. All right. Okay. Intestacy. Okay. This is, I think, what you were talking about, Oscar. Intestacy is the condition of an estate of a person who dies, owning property greater than the sum of their enforceable debts and funeral expenses without having made a valid will. In simple terms, someone who dies intestate didn't make a will. That's it. They did not make a will. So the question is, if someone dies and they didn't leave a will, but they own property greater than the sum of their enforceable debts. In other words, say they owe, their debts come up to maybe $5,000. Just say hypothetically, that's the sum of their enforceable debts, and $5,000 could say they owe. Make it easy. They owe $5,000 to the IRS. Okay, but when they die, they have $50,000. Okay, so that means they've died. They don't have a will. They have property that's greater than the sum of their enforceable debts, i.e. the IRS. They owe $5,000 to the enforceable debts, okay? and funeral expenses, which is only $200, which is Potter's Field. They just bury people who don't have money. The city buries them in Potter's Field, okay? And they die without having made a will. So that means that technically this person has $45,000 still left, and they made no will, okay? So the question is then what happens, okay? They died intestate. They have $45,000 left after their enforceable debts of $5,000 that they owe to the IRS is used. How does the 40, and they have 2 kids. How is it divided up? How do you know how to divide up this money? Oscar.
Oh, in terms of a person who died without a will, there's an order of things, but I believe now it's by representation, or like I know there's like per capita and per stripes, but basically like whoever, it's by representation, and like you would go to the nearest relative, and they get the most like cut, and like it just gets keep getting smaller as it goes down the family tree.
Right. There is actually, if you don't make a will, it's simply put, if you don't make a will, the government will make one for you. That's all it is. And they will do it in the fairest and most equitable way that they believe they're making it. In other words, if you had 2 children and you had $45,000, okay, they're just cutting it, okay, and you're not married, okay? Well, if you're married, then it's simple. Everything's going to the wife or the husband. Then that's the end of it. There's nothing more to say. If you're not married, okay, they're going to say if there's 2 children left, everything goes to the children, 1/2. That's all. They just break it up. If there's 2 children but one is dead, but that one child who died has two children, then the 1/2 is going to go to the one child who is alive, and the one who's now deceased but has 2 children, his half will be divided 1/2 between among the 2 children. It's simple. They make it very, very, very simple. It doesn't get into any, because it has nothing to do with like, dislike, or they don't know anything. It's just a simple formula. And I forgot which book it is, and I can just email it to you. But there's a book that actually describes which how the law of intestacy is supposed to be carried out. All right. So last will and testament, in the strictest sense, will, the word will in the word last will and testament, okay, has historically been limited to meaning real property. In other words, will meant real property, and real property is land, okay? And this is going back for years. Will has always meant land, all right? While the term testament, last will and testament, applied to dispositions of personal property, i.e. cell phones, whatever, selfie sticks, whatever, cars, personal property, things that you can't move, okay? Land relates to land, the ground, and structures that are on it that you can't move, all right? So will has historically meant real property, meaning land, while testament applied to personal property. That has historically been how those statements came up. So, however, this distinction between these two are seldom observed. That is simply an historical, edict, and that's not something that is being followed anymore in terms of, how they look at things, right? Okay, so a will is a document that says who, meaning who's a person, okay, and or, all right, what, right? And I say what, all right, because you can leave property to a person, you can leave it to a company or a corporation or a partnership, right? People have left money to dogs, okay, to cats. This woman, like 5 years ago, she left like $2 million to a cat, in the city. It was insane. But you leave $2 million to a cat, I guess you're leaving money to the caretaker, because there's someone who has to get paid to take care of the cat, and it's just insanity. But who or what? So you can leave money to a corporation. There's some people. What's a corporation? Your school is a corporation. All right. There's some people who die. They leave a ton of money to St.Johns University. You ever wonder how some of those buildings have certain names on it? Okay. those names of wealthy contributors. They're just not like nice people who, oh, this guy did great in class. Let's name this building after him or her. That's not it. They've left the university millions and millions of dollars. So I think there's one building they changed the name from just recently. I forgot which building.
Yeah.
Right. It had a different name on it before. Someone ponied up a lot of money. They took the other person's name down and put their name up. So, so who, what will get all or some of your probatable property, okay? And this word is important, probatable property. Probatable property is property that does not transfer to someone or something by means other than your will, okay? I'm gonna explain this to you, such as a beneficiary designation or property held jointly in a trust. Again, a will says who or what will get your all or some of your probatable property. So I'll give you an example. Very simple. You guys know of Social Security, right? Social Security, pensions, right? And life insurance policies. Okay, all right. Andre, if you're gonna fill out a life insurance policy, how would someone do that? What do they do?
What do you mean?
Well, you want to take out a life insurance policy on yourself, right?
Right.
What else do you do with that policy? That you take it out, but
Well, you have to assign a person who's going to receive the money when something happens to you.
Exactly. Now, that person is called a beneficiary. Exactly. Right. When you fill out Social Security, when you fill out your your Social Security card, well, you got your Social Security card already, but when you go onto the Social Security website, you have to also choose a beneficiary designee in the event you die. Okay, when you life insurance, when you have a pension, if you have a job that you're so lucky to have a pension on. One second, Mark, close the door. Okay, when you have a job that you're lucky to have a pension on, you also get to designate a pension a beneficiary. So what does this mean? Okay, it means the following. When you make that choose that designation, that pension, that life insurance beneficiary with like what's the life insurance company? New York Life Insurance Company. That means that you have to contact them. You get their paperwork. You write down the name of your friend or your son or your daughter, whoever it is. You write down a name. In the event I die, I leave them. This was get all the proceeds of your life insurance policy. Good. Now, just say that 20 years down the road, okay, you have 2 children, and because you divorced your wife, you have 2 children with the new wife. The first child was that you had with the ex-wife. That was a person who was the designee on the life insurance policy. Now, 20 years later, you have 2 more kids. You write up your will, and your will says, I leave, my house to this, my house to that, and I leave all the proceeds of my life insurance policy with New York Life to my children, A and B, with my new wife. Okay. Now you die, and now it's you're at the courthouse for the will to be probated. What's going to happen? The judge is going to pull out the will. He's going to read the part that says, "Oh, this money from the life insurance policy is supposed to go to A and B from the new wife." And guess what? They're not going to get it. They won't get it. Who's going to get the money?
The first kid.
Exactly. The first kid gets the money because the proceeds of a life insurance policy, of a pension, of a Social Security beneficiary do not travel through the will. They travel outside of the will. What the hell is that?
Are you able to change that in the future? Or you have to get like a new plan?
What you had to do, if you wanted to get someone, if you wanted to get someone else to be the beneficiary of that money, you needed to call up New York Life or go down there, have them send you new designee forms, erase, cut out, the person you previously had before, and put on the new 2 kids, okay? Because when you fill out these beneficiary designees, that is a contract between you and New York Life, for the pension. It's between you and the Social Security agency for the Social Security. So nothing you write in your will ever change that. So what I'm saying here is that the will says that which of your probatable property, okay, you will get. Probatable property, that is property that passes through the will. Probatable property is property that can be probated, okay? The court cannot probate the life insurance pension beneficiary or the Social Security of someone whether they're not the designee. Everyone understand that? All right?
Now, I thought all kids actually had equal rights to life insurance policy.
No, not at all.
The life insurance.
Not at all. Not at all. No. You can give. I mean, just assuming that there was no. Just assuming there was no issue. First of all, again, the life insurance policy is not going to be distributed by through court. That's going to be distributed when someone passes. Someone's going to call up the New York Life and say, "This person died. Okay, who are the 2 beneficiaries?" And it could be that one person is slated to get X. You could actually apportion it. You could have done that from the time that you actually wrote it out. All right. If you don't write anything out, then everyone's going to get in equal shares. Okay. If you don't do anything, but you can apportion it as you choose. So it's not, the default is to give, equal, but that is changeable. Right. So again, items that pass through the will are considered probatable. And those are the things that can be affected by a court. If they don't pass through the will, nothing you say is going to change it. Yes?
We're talking about only money that comes from actual life insurance, not everything else.
I'm talking about money.
There's money that comes from the insurance policy itself, and then you own a house, right? So if you name child A to get the life insurance policy money, but you don't specify anything about the property or the house, I'm assuming the house is going to be divided equally.
Yeah, if there's no wife, if there's 2 children, then one child would be getting whatever they said in the life insurance policy, and will get half of the house too with the other person. Correct. Right. Exactly. But if there's a wife, they're getting, right?
Yeah, I'm just talking about like 2 children. Okay.
Yeah.
But doesn't the wife? That's only if there's no issue, right? Like if there is an issue, like if one of the kids starts to conflict, then it's like the first half to the wife, and then something about the residual.
Right, there's a residual estate. Exactly. So in New York, you cannot, and actually in most states, you cannot disinherit your wife. It's not possible. A spouse, you can't do that. You have to leave them at least half of the estate. And obviously, by default, most of the time, the way most wills are written is that if I die, I just leave everything to my wife, and I may have wishes that she do this, she do that, she do that. But of course, since she's still alive, she can do what she wants. Now, obviously, I can also say, oh, I want my son to have this car, my son to have that car. That would have to be carried out. But basically, once there's another spouse living, it's presumed that they're gonna, it's like joint tenancy. They're gonna inherit the bulk of the estate.
What about like a prenup? Wouldn't that be like a way to like disinherit?
Oh yeah. Prenup was just gonna if it's well written, that's gonna keep that new spouse out of it completely, and skip right to the kid.
Half of the estate has to go to the wife.
Yes.
No.
Yeah. And let me just say something. In when people were writing wills, they always wanted to make sure that, just say you had 4 kids. If you had 4 kids and you 3 of them were like really great, and one of them was like a pain in the ass, okay, and you did not want to leave that child anything, okay. If you leave that child nothing, if you give 1, 2, 3 something, whatever, and then you leave that 4th child nothing, that person, that 4th child would have a very good chance of contesting the will by saying, but dad told me or mom told me that he was going to give me, a quarter of the estate or something like that. He could say that, okay? Here's what people do in order to avoid that. They give, child A, B, C, whatever amount they're going to give him, and they would give child D $1. Why would they do that?
So they can't say they didn't get anything.
More importantly, they can't say that he didn't think of them. You understand? That means that he intended to you to only get the $1 because he actually thought of you and just gave you that. So that's better than not giving them anything and then being able to say that dad said he was going to give me, or mom said she was going to give me this or that. So that's the nasty way that people do things. Okay, all right. So
Professor, can you just repeat when you said the court cannot probate through the will, the things they cannot probate again? It was the pension, insurance policy. Was there a third item?
Social Security.
Okay.
Basically, anything where you have to write down or choose a beneficiary at the time, at the time you fill it out. Yeah.
Okay.
Yeah. Anytime you have to do that, that is a contract between you and that agency, and that does not pass through the will. No will can change that. Okay. So again, who or what will get some or all of your probatable property on your death, and who is in charge of managing the will when you die? Okay, the will requirements for creation. Any person over the age of majority, that's age, what's that? How old is that?
18.
18. Excuse me, 18. Any person over 18 can draft their own will with or without the aid of an attorney. So when it says with or without the aid of an attorney, do you need an attorney to draft a will?
Preferably.
If you're under 18.
Well, yeah. Well, look, if you're under 18, you can't write a will because you can't contract. The will is a contract in a sense. So forget that.
What if you get legally separated from your parents?
At what time? When?
17.
Well, if you get legally separated from your parents and you're doing what and what?
You don't have any guardian.
Then at 17, you're not emancipated yet, so you can't even, you're not going to really be able to write a will. You have to be over the age of majority to write a will. Period. And if you're emancipated, you might be emancipated for other things, not for leaving property. Maybe you're emancipated for the purpose of getting a federal loan, for school or something like that, but not for leaving property. Okay. Let me just check. Any person with age 18 can draft their own will, so you don't need a lawyer. Now, Oscar was right. It's preferable that you have a lawyer. That is preferable, but you don't need one, right? Okay. The testator. Go ahead.
Do you need to be a certain age to accept the property or money?
No. They can leave money to a child. And that child, hopefully, they set up a trust for that person as well. So you can leave money to a newborn. If you can leave money to a dog, you can certainly leave it to a child. Yeah, they don't have to be any age. There's no age requirement on accepting. There is an age requirement on making. All right. Okay. The testator must clearly identify him or herself as a maker of the will. That's usually at the top of the will. It might say, I, Kenneth Holder, declare that this is my last will and testament. You have to. It's called a publication. All right. This is your public. You're saying to the world that this is my last will and testament. So it has to say who you are. You can't use like a fictitious name. You can't use a nickname. You have to use your government name. Okay. So the testator must clearly identify himself as the maker of the will, and that the will is being made. All right, commonly referred to as a publication. All right, and it's typically satisfied by saying again, "This is my last will and testament." And every printed will that you ever get, that's pre-printed, always says that. It's not something you have to write in. Okay.
You have to specify that you're also of sound mind.
I'm sorry.
You have to specify also, I think, that you're of a sound mind.
No. Some wills actually do say that declare that I'm last will and testament and that I'm of sound mind and body. Some wills do say that. I think the only issue with that is why you have witnesses to the will. Witnesses to the will are going to, they're there not only to witness that you signed the will, but if there's a challenge to the will, they're there to say that, they spoke to you, you were coherent, you were not, you were not drunk, you were not inebriated, you appeared to be of sound mind and body at the time you filled out the will, and they signed it, when you signed it in your presence. The testator should declare that he or she revokes all previous wills and codicils. What does that mean? Alexis. I can't hear you.
Yeah, I mute my mic like every once in a while
No
because
problem.
screaming children.
Yeah.
So in order to like create a new will, he has to make all the other wills basically like null and void.
Exactly.
Yeah.
Exactly. There's some people, believe it or not, there's some people who like they make wills like every year. Every time, or every time they get in an argument, they change the will. Because I don't like you anymore. I'm changing it, and they use it as leverage to say, you know what? If you're good to me, I'm going to leave you this car, this Ferrari. They use it as leverage. So they change them all the time. So the problem is that so the question is, which is the one that's valid? Well, the one that's valid should be the last one, okay? And the last one should actually say that all the other ones that come before it, that are dated before it, okay, are null and void, okay? And if it's not, and that's the question, if it does not say it revokes the previous wills, then here's where you come to. If not, then a subsequent will, okay, a later will, okay, revokes earlier wills and codicils only to this codicil is the same as a will, only to the extent to which they are inconsistent, okay? So if you don't say I'm revoking the prior will, okay, then that means the new one that you wrote only revokes the earlier wills only to the extent that they are inconsistent. What does that mean? Very simple. Just say the earlier will left, like a new, like a sofa set, a Ferrari, and a and a new I don't know, a new LED TV, sofa set, Ferrari, LED TV. Okay, now that person makes a new will. Okay, they don't say it revokes the previous codicils, but what they do in the new will, they say they're leaving the sofa set and the LED TV. Okay, so they left out the Ferrari, right? They left that out. So what it means is this: even though they just say we're revoking the prior wills, if the prior will and this will are exactly the same, except for one thing, okay, then they'll still go with it. Okay, it's like, okay, he or she forgot to put that in, but it's clear in this second one that the second one is identical. I mean, this newest one is identical to the older one, except that they changed one thing. They left the Ferrari out. They didn't give the Ferrari to Harry. That means that Harry's not getting the Ferrari. So like Harry could not come back and say, well, wait a second, that second will, the will right before this, it left me a Ferrari, and this newer will, it doesn't have it. I think that the older will should be the one that we look at. A court would say no. Everything is exactly the same on this new will, except it's left out the Ferrari. And even though he didn't say I'm revoking the prior codicils, he must have meant to do that because he left it out and left everything else the same. Okay, all right. That's just looking at the two and saying, well, are they the same? However, okay, if the newest will that's done is completely different than the older one, okay, completely different, right? Even though he doesn't say, or she doesn't say that he's revoking all previous wills and codicils, then under the law, that previous will is considered completely revoked by implication. Okay, revoked by implication. What they're saying is that he must have meant to revoke, the previous will, because this new will is completely different from it. He changed everything around. So we're going with the new will. We're going because it's the newest date, and the whole thing here is, it's a new will because it has the most recent date, right? It's got the most recent date, is completely different from any will before it. And even though he didn't say I revoke in all wills and codicils, they're going to go with it because it's a brand new, different will. Okay. So again, if it's just one little detail that's different, okay, all right, that will still save it, even though he doesn't revoke. And if it's completely different, then that will still save it, but it's just gonna completely revoke the old will, the earlier will, and the new one is gonna be in its place. Some people forget to write these things. That's why there's these companies called, Zoom. Believe it or not, it's called Zoom. It was put on by that same guy who, the same guy who did one of the guys who defended OJ in his trial. I forgot the guy's name, but he's one of the attorneys who defended OJ, and after that he opened up a company called Zoom.com. Zoom.com is a company that makes wills, and the easy thing about having a company that makes wills or just getting one that's pre-printed is that all of these words are in there already. No one's going to make a mistake about putting it in there. Okay. Right. Also, the testator must sign and date the will. You have to sign and date it. Why do you have to sign and date the will?
So we know when it takes effect.
The latest one.
Who said that? The previous one?
So we know when it takes effect, effective as of.
Right. And more importantly, what does it say about anyone that came before it?
But it's null and void. Every other one.
They're null and void. Right. It says they're null and void. That's what it says. So very important. Very important. It says they're null and void. Now, so you have to sign and date the will, usually in the presence of at least two disinterested witnesses. Okay. So in New York, you have to have at least two people who signed the will. All right. Who witness you signing your will and who sign it themselves. And they have to be what's called disinterested. They have to be disinterested. A disinterested witness is a person who is not receiving something in that will. You understand? What does it mean? So just say I'm the one who makes the will. I make up a will, and I say that I make someone the executor, and then I ask two people. I ask Oscar, I ask Victoria to watch me sign this will, to watch me sign the will, and I need you to sign it as well. Well, but at the same time, I say, okay, Oscar, I'm going to leave you my house in the Hamptons, and Victoria, I'm going to leave you this Ferrari, okay? And you sign the will. Now, when I die, the will gets probated, okay? And maybe one of the children wants to challenge the will, right? Now what happens? When the will gets challenged, they're going to say, well, Dad never signed it, or Dad was not of sound mind. So how do you prove that I was of sound mind? You have to call Oscar or Victoria, okay, or anyone else who was there to come and actually give testimony about my condition, right? But if they look at the will and say, wait a second, Oscar is going to get a Ferrari, a house in the Hamptons, and Victoria is going to get a Ferrari. What are they going to say about Victoria? What are they going to say about your testimony with respect to whether or not it's credible in terms of saying that this will should be upheld?
Well, it's not, because if I'm getting something, then I'm not not disinterested witness.
Right. You Oscar, you agree?
Yeah, there'd be a conflict of interest.
It's a conflict. You're never. Go ahead, Andre. What do you say?
If something happens to the witness.
Okay, we'll get to that. We'll get to that in 2 seconds, Andre. Okay, so you guys are 100% right. The reason that's a problem is because it's very unlikely that you two are going to say the will that I was not in, did not have, sound body of mind, because you people are going to receive under the will as well. So if you say, yeah, you know what, Ken was crazy when he signed it. He looked like he was drunk to me. Then the will is invalidated. Okay, it's going to fall into intestacy, and you two are not going to get whatever I left you. So you have to be two witnesses who are disinterested, and a disinterested witness is someone who, although a witness to the will, is not going to receive anything as a consequence of the will. Now, Andre said, what happens if the witnesses are dead? Well, that becomes a problem. That's why we go to this section right here called supernumerary. Okay, what most people do, New York, you need at least 2. Most people use at least 3. Okay, and it's usually unlikely that 3 people are dead, but it's not impossible before your will actually gets probated before you die. But it is possible. So the first thing to know, I would just want you to know before I get to Andre's question, is that any witness past 2, okay, that third witness is called a supernumerary witness. Any witness past the 2 that's necessary are called supernumerary. So if someone has 5 witnesses to their will for whatever reason, that means he has 3 of them are considered supernumerary witnesses. All right, that's very important. Now, the reason people have 3 is for what Andre said. Suppose witnesses die. If all of the witnesses are dead, basically, and the will is challenged, okay, and that challenge cannot be settled, that will be settled as though he died or she died intestate, okay? Because there's no way to validate the will unless somehow the parties come together. Now, a lot of times, Andre, that's very unlikely that happens, because once there's a challenge to the will like that, whatever the person was trying to get, who was trying to get from the will, who wants to challenge it, once it falls into intestacy, which is just a cold reading of who gets what, whatever they are fighting for the will, for, is very likely, very unlikely that they're going to get that. You understand what I'm saying? So a lot of times families get together and they say, you know what, let's not. It's kind of stupid for us to challenge this thing because none of us are going to end up with anything if we challenge it like that. Why don't we just leave it and just work it out amongst ourselves? That's what happens. Right?
You're saying that, for example, the child that's not in the will won't challenge it. Well, shouldn't challenge it if something happens to the witness.
Well, no. I'm saying first of all, if there's someone who's not in the will, okay, that's a problem number one because they're not in the will. They shouldn't even be considered. But
right. Well, suppose they are in the will.
Okay, so if they are in the will and what and what's the question?
I thought it's going to be like the other way around, in that if there is a witness, there is a reason to not challenge it, because you saw that well, not if you saw, you know that there's a witness who witnessed the guy signing the will, as opposed to if there's no witness, then maybe that gives you some leverage in terms of challenging the will.
Well, if there's no witness to the will, if there's no witness with no witnesses, then it's going to be difficult to probate the will if there's a challenge. Okay, if there's no witnesses and there's no challenge, then the will can be probated. If there's no one saying, okay, I don't believe this, in other words, the only reason that witnesses are called to the court to say what they saw is when someone is questioning whether or not the person who signed the will was of sound mind and body. That's it. That's the only reason you'd call up any of the witnesses if there's a challenge. If there's no challenge, the will gets probated just like it says. X gets Y, Y gets Z. There's no.
No, what I'm saying is, isn't it better to challenge a will when there are no witnesses?
Well, yeah. Once you challenge it and there are no witnesses, okay, then you're gonna probably push that will into intestacy, okay, and then whoever the person is who's challenging it, whoever that is, wherever they are, if it's the grandkid or the granddaughter or the great granddaughter, they're way down on the line, okay. That means if there's other people who are alive, okay, who are named who by through intestacy would normally get, those people are going to get long before that grandson or that granddaughter. For whatever reason they're challenging, maybe they thought they're going to get like $500,000. It's very unlikely if the estate is only worth, like $1 million. It's very unlikely they're going to get whatever they're trying to get by challenging it, because you push it into intestacy, and the people above you, they're going to get their shares before they even get to you. So it's like a chess game. You have to really think about, is it smart to do this, or maybe I shouldn't. You have to pick your poison.
Mm-hmm.
All right. Okay, here. It's sort of comes in under here. If a witness is also designated, if a witness is designated to receive property under the will, okay, that they are also witnesses to, meaning they are an interested witness, okay? Remember, you want a disinterested witness, someone who's not going to receive property. If you're going to receive property under the will, you are an interested witness. So what could happen? Do we have to invalidate the will? Well, let's see. So there's a couple things that you can do here. The effect in many jurisdictions are the following. One, okay, they are disallowed to receive under the will. And so Oscar, when Oscar was supposed to get that house in the Hamptons, and Victoria was supposed to get the Ferrari, okay, one option the court has is to simply say, Oscar, you're not going to get it, and Victoria, you're not going to get it either, okay? You're disallowed to receive under the will. That makes you just now uninterested regular witnesses to the will, okay? Or here's the other option, or your status as a witness is invalidated. So this is why people have more than two witnesses. So say Oscar, Victoria, and Alexis all were witnesses to a will, okay? And Oscar was slighted to receive under the will, and in the state, he's supposed to get a Ferrari, and that means he's an interested witness. The will was challenged. In order to, a matter of fact, just say Victoria and Alexis were no longer around, then, well, actually, Victoria was no longer around. Alexis is still here. Oscar's getting under the will. In order to allow the will to still be probated, okay, Oscar will be, his status as a witness is invalidated. Boom, you're gone. The only witness there is to this will, for the purposes of continuing with it, is Alexis. So there's, like I said, there's two options. I'm sorry, go ahead.
No, you go.
Hmm?
Can you claim a witness to be biased?
I'm sorry?
Can you claim a witness to be biased?
Of course you can. 100%. I mean, this is the Hatfields and the McCoys. This is the worst of like what families go through all the time. You know, where they're just fighting with each other. You know, all the time. It's exactly what you say. That's exactly what they do. It brings out the worst in everybody. You know, and that's why people just try to settle things. So again, very important. Go ahead.
How would the court look at it in that situation?
Well, the court doesn't care that they're fighting with each other. The court just will take a cold reading of what it is. The court's not going to get emotional into, you know, or consider the emotional, you know, comings and goings of these relatives. They will simply take a cold reading of what it is.
So what if this witness is suppose a close friend to one of the recipients of the will? Wouldn't that, if you claim the witness is biased, shouldn't the judge kind of look into it a little bit?
Well, I mean, the judge is not going to conduct an investigation. You know, I mean, in other words, that may be a function of someone's mind. What's in someone's mind? You know, I'm really close to this person, and the question is, okay, you're close to him, so what? You know, does that mean that person is lying or is going to lie to do this? So, you know, I mean, that can lead you down like a very bizarre path. The question is who is named in this will to receive and who is not, and who are the witnesses to this will that are legitimate witnesses to this will. In other words, they're legitimate in that they're also not receiving under the will. That's it. You know, the court's not going to get into, because then the court will be in the middle of this like family feud. It's not going to happen. So again, if you're supposed to, if you are an interested witness, if someone left you property in a will, okay, and you are an interested witness, in some states they will do one of the following. They will say you cannot receive under the will. That's A, what you were supposed to receive. I've invalidated it. So now I will accept you as being a witness. Was a person of sound mind and body, or your status as a witness is invalidated. You're invalidated. You're gone as a witness. We still have two others that are left here. I'll ask them if the person was in sound body or mind. Okay. And last thing. Oh, important, very important. The testator's signature must be placed at the end of the will. Why? All right, it says it right there. Jesus. Go ahead, Oscar.
Validated.
That's one, but more importantly,
it would defeat the testator's intentions.
That's it, but not. There's more.
Is it kind of like in the waiver, like you have to read the whole thing and understand it, and like in the will, like you have to read the whole thing and state it to like And you sign it like you agree to that type of thing?
Well, yeah, for the most part. Let me ask you this. You guys written out checks before? Checks?
Mhm.
Okay. When you write out a check, if you write out like say $25, right? You then write the the words out. You write out the word 25, and then you put what do you put? You put a line, right?
Right.
Why do you put the line there? That line goes all the way to the box. Why do you put that there?
To ensure that nothing comes after.
Exactly. So if you didn't have that line there, someone might someone might take your check and change that 25 to put 2 more zeros on it at the end, okay, and or 3 zeros or whatever. It's to prevent anyone from adding anything to the to the end of the will. So what it says here, if the testator's signature is at the end of the will, okay, that's it. Everything that concerns that will, it has to come before it. If something comes after it, okay, then it generally would be ignored because it's presumed that, well, it's almost like if I wrote a will, you guys witnessed it, and then later after you were gone, I decided to change it, okay, and just write something at the end, like after everyone's signature, on the bottom, okay. If it gets challenged, you guys will say, well, I didn't know anything about that. I never even saw that. I didn't know, where did that come from, all right? So the testator's signature must be placed at the end of the will. If this is not observed, any text following the signature will be ignored, okay? All right? Or the entire will may be invalidated if what comes after the signature is so material, okay, that ignoring it would defeat the testator's intentions. Okay, how does that happen? Okay, so just say the first part where it says, must be placed at the end. If not, if this is not observed, any text following it will be ignored. Say in the first one here, I leave you, I do my will. You guys witness it, and at the end, I write down that, you know what, I'm going to leave this $250, to Jugs, and no one ever witnessed it. Okay, when the will is probated, okay, that will be ignored. Okay, because that comes after it. That comes after the signature. Now, the second one, after you guys leave, okay, I decide to write down, you know what, I'm leaving my second mansion, okay, in the Hamptons, okay, to Victoria, right? Now, that means, or the entire will may be invalidated if what comes after the signature is so material. That means it's so important. It's a whole house, not $250, but it's so huge, okay, that ignoring it would defeat the testator's intentions. Okay, so they're saying if that's the case, that means that the whole will is getting invalidated because now we don't know what this guy was doing or this girl was doing. Okay, it means that he should have just wrote a new will and had new people, witnesses come and witness that, because he's leaving a whole house to someone else, worth millions of dollars. That means that something's wrong. So those are two options. If it's something small and stupid, it's just going to be ignored. Forget about it. If it's material means big, large, significant. Okay, that's what that means. And that's it. That's it. Okay, this is the next thing, but this is next week. So what I'm going to do, the next topic is going to be this. I'm going to send you information on this. I'm going to look over my my emails. I do believe that I wanted the how do I get out of this screen? Let's see. Stop sharing. Boom. Okay, good. I do believe that I can that I'd wanted the will homework by next Thursday. Okay. Next Thursday, I'm also going to give you a quiz on this, what we just did tonight. You guys have the PDFs on this, right?
No.
The PowerPoints?
Yeah, the PowerPoints.
Yes.
Yeah, I sent this out already, right?
Yeah.
So that's it. So I figure, did they change the school year ending? Did they say when's it end? In May, right? Your
I think
year?
it's May 13th, if I'm not mistaken.
13th, right? I believe I'm going to have one quiz and just a final from this class, and I'm going to post two things that, and they will just simply be like, you know how I just sent you that article on waivers, liabilities of waivers. It just may be two things. One might have to do with the common law, and another topic that you could just write a two-page report on. That will be for extra credit for those who want it. But I think those two tests that I do, the final and this other one, that will set you up, you know, well for you know, for the grade that you get in the class. So this class just now, this lesson, that quiz will be next
What
week.
was the thing that we had to write on?
It on a will, a sample.
Oh
will.
no, I thought you said it was something else.
Oh
I'm
no,
sorry.
I'm gonna send out extra credit like in about a week of, if you wanted extra credit, just one or two topics. I haven't decided on them, but they're almost in the area of common law or something like that. Just to write on that two-page report on that to submit it before the final.
Oh, okay.
That's for extra credit. That kind of stuff.
Actually, that next Thursday we have a quiz and homework for the wills.
Yeah. So next Thursday will be the quiz and the homework for the wills. Yep. That's it. All right.
What's the will homework, Professor?
Just I sent it to you already. I sent you sample, just like the waivers. I sent you sample wills. I sent you 3 wills of samples. Some of them are straightforward. Some of them are a little involved. Some of them are like middle of the road. Just choose whichever one you want and rewrite it, you know, running your own will. That's all.
Would you mind sending that again? Because I have these slides and I have this rules of evidence, but I don't remember seeing that one.
I do have like a separate will from another class from my probate space coach. Just email that to you.
I don't
today.
think I received anything regarding wills.
Yeah.
I think.
Oh, sorry. Hold on.
Is that all right with
I
you?
have like the notification, but it doesn't specify really what the assignment is.
Okay.
Yeah, and I printed everything when I got the email, and all I have is just the primary and I think
Primary and secondary, right.
Yeah, primary and secondary, and then I also received like rules of evidence. I hope this was this one.
Yeah.
Really?
But I didn't, yeah, and then just the YouTube link I think was another email you sent out separately.
Right. Okay.
Um,
So you said you don't have the sample wills?
No, and we also didn't. I don't know if it was just me, but I didn't receive any information regarding the homework assignment.
I didn't get that.
Yeah, there's nothing on Blackboard either. It's just the PowerPoint and then like the primary law and secondary law.
Yeah, just these 2 handouts that.
Yeah.
Yeah.
Okay. All right. So I will send that out tonight.
Okay.
No problem.
And I have another question. Are you going to continue all of our classes in this format, or are we going to do like the YouTube and switch back and forth depending on the topic?
I think this next topic I really have to do it like this. I do. I can actually get away with the last topic, which is
Power of attorney? No.
power of attorney. Yeah, that one I can actually do a YouTube on that one. I can actually do that. Because,
Okay, so it's going to be pretty much split for the rest of the semester.
Yeah.
With the Zoom and the YouTube.
Correct.
Okay.
As of now, the next class will be next class is homework and the test.
And the quiz, right?
So I could just send it to you that day, but the homework will be due that day. The quiz I'll give to you, it'll be due the quiz you're not doing it in an hour. The quiz I'm giving it to you and it's due about like the next day. So next week I'll do the lesson on reading a legal opinion. I'll do that. So like I said, so you're gonna have a day to do the quiz, okay, and send it back to me, and then you'll give me the homework on the wills, the waiver, the fictitious wills, and I'll do the I'll start the how to read a legal opinion. But I'll send out tonight which thing I'm missing. I'll send it out. Okay.
Could I email you a will that I did for my other class?
Okay.
Is that all right?
Yeah, that's cool.
Okay.
All right, guys, you good?
Plus, let me ask you something.
Yep. Andre?
Remember how you said that full participation is half a grade and half a letter grade, and full homework is
And
another
full homework, right,
letter grade?
right,
So
right.
with participation, it's a little iffy, right? But full homework is still half a letter grade.
Yeah, the homework is still half letter grade. The participation, I have to obviously, take professors, uh, you know, I gotta, figure out how to make up for this in this little bizarre world that we're in now, and make up for it. So, and I'll do it. I'll figure it out.
And I'm sorry, will the quizzes, will the quizzes still be 10% of the grade?
Yeah, I was dropping the lowest one, but that's still my intent. And again, I have to look at that again too, because that's changed again. I have to look at a lot of things, figure it out. But we'll get through it. I think you guys will all be fine.
Professor, when I dialed in earlier, it just froze, said it was waiting on you to allow me in.
Well, what happened is that it's good if everyone dials in at the same time, because once I go to full screen and I'll try to, then it didn't allow me to show me the waiting room, to show me that people were waiting. So I had to just keep going out of that to see if anyone was waiting, and then I saw, okay, someone came in. So as I figure this out a little bit more, I'll get better at it.
Okay.
My apologies. Right, but I did record it, so I'm going to send this link to the class so that they can get it for those who didn't get a chance to get on here.
So you're going to send the recording from this lesson out on Blackboard or on email?
Well, here's the thing: when I send things out on Blackboard, it's supposed to go to.
I usually get the emails when you post an announcement or an assignment. I usually get an alert.
Right.
But I don't know if it's the Blackboard email or if it's your email, your personal email.
I've actually never sent something out unless it to the whole class from St. John's email. I've never used that for that. Because it's like a pain in the ass to get all these names together. Okay, so when I go into Blackboard, it just says all users, and it just knows who all the users are. But like if you ask me a question, then I always respond to you in the email back and forth. That I will do.
Okay.
So anything that you've gotten has come straight up through Blackboard.
Yeah.
And a lot of times in Blackboard, I go right to the email section and post it right there, so it should go directly to email. So I'm going to post the link to this, or however I'm going to upload it. I got to figure out how to do that. Because I think I'm recording on my machine. That means I have to put the link somewhere, because it's not linking to my machine because it'll be open. I might have to, I don't know. I'll figure it out.
Mm-hmm.
The slides are going to be on Blackboard though, right? The slides, those you had like 70, 79, all those slides that we were reading are going to be on Blackboard.
Oh yeah, yep.
Okay.
I'm gonna put the slides, the actual sample waivers, and slides and the sample waivers, right? Okay.
And the will, the sample will.
Right, of the wills, right. I mean, forget the waivers, the wills. I'm just getting confused. The will one, yes.
Okay.
All right, guys.
All right. Have a good night.
You guys take care of yourself. Thank you very much.
I'm sorry, just one more thing. As far as the next Zoom class that we're gonna have, you're gonna notify us via email, right?
I'm sorry, what did you say?
As far as this next Zoom class that we're gonna have,
I'm gonna notify you by email, just like I did. Yep. Whichever one is gonna be, you're gonna know like a day or two in advance. Yes.
And so the work that's gonna be due next Thursday is just gonna be the will.
The will waiver.
And then we're just gonna have a class.
Yes.
Okay, perfect. Thank you.
Right. Cool.
Thank you.
Guys.
Have a good one.
Guys, take care. Yep. Bye now.
Bye.
Yep. Okay. How do I end this? Stop.